Good morning, ma'am, and to all the participants. I, Avneet Kaur, volunteer of Sambhav Initiative and moderator for this event. On behalf of organizing committee, I extend a warm welcome to our esteemed dignitary, Varuna Bhandari Nani ma'am, and to all the participants in this 2 weeks online national capacity building program on art of contract drafting from fundamentals to enforcement, organized by Sambhav Initiative, which is working towards alternative dispute resolution, free legal aid, mental health, and treating legal literacy under the direction and guidance of Patron in Chief of Sambhav Initiative, Honorable Justice C.K. Thakkar, sir, former Judge of Supreme Court of India, and Patron of Sambhav Initiative, Honorable Justice Emma Shah, sir, former Judge of Supreme Court of India, in collaboration with Pro Bono India, which is working towards legal aid and legal literacy. Where today's session is all about contract negotiations and its techniques. Before we start the session, please adhere to some webinar etiquettes. I request all the attendees to keep their microphones muted during the session. If you have any questions, you can raise your hand or ask a question in the chat box. It is my privilege to have with us an honor to introduce Varuna Bhandari Gugnani ma'am, Senior Trainer, Mediation and Conciliation Project Committee, Supreme Court of India, and one of the first trained mediators of the Supreme Court of India. With a legal career spanning over 30 years and the past 12 years devoted entirely to mediation, ma'am has made significant contributions to transforming the concept of dispute resolution in India. Ma'am is empaneled as a mediator with the Supreme Court Mediation Center, Punjab and Haryana High Court, Delhi Mediation Center, and Delhi Dispute Resolution Society. Ma'am has conducted over 2,000 mediation cases, including more than 100 matters at Supreme Court level. Academically, ma'am holds a BA from Kurukshetra University, an LLB from Delhi University's Campus Law Center, and a postgraduate diploma in area from Indian Law Institute, New Delhi, and has completed multiple national certifications in mediation, civil, and commercial negotiation and international dispute resolution from institutions like IICA and IIAM. In litigation sphere, ma'am has served as panel counsel for Union of India, the state of Haryana, and various public authorities. Ma'am has appeared in several landmark public interest litigations, including Lakshmi versus Union of India, Right to Education case, PUCL versus Union of India, Safai Karamchari Andolan, and others. Ma'am has also represented the Union of India in significant arbitration matters such as Reliance Telecom versus Union of India and Tata Teleservices arbitration before retired Supreme Court judges. Internationally, ma'am is a fellow of International Academy of Mediators and has contributed to global mediation forums in Singapore, San Francisco, Vancouver, Frankfurt, Edinburgh, and was also an organizing member of the Global Pound Conference India Series, Chandigarh, a pivotal event in shaping discourse around model laws for cross-border mediation. Ma'am is also actively involved in pro bono mediation services, helping underprivileged individuals, NGOs, and communities in need, driven by a strong sense of social responsibility. We are deeply honored to have you with us today, ma'am. Over to you, ma'am.
Yeah, good morning. Good morning, everyone. Can you hear me? You
Yes,
can.
yes, ma'am.
Yes. So, thank you, Avneet, for such an elaborate introduction. I have forgotten, over 35 years what all has been done and what all, I do. But presently, yes, I am fully into mediation, and last since 2014, I ventured into mediation completely. So when I was asked to speak on this topic, so each time I would look at this topic, I would think that it is all mutual. It is all mutual. So it was very interesting. So welcome everyone. See, Sambhav is doing a great job as well as legal literacy is there. So every year they are doing programs which are not taxing on your time, but yes, involving people from all backgrounds. It is not only about lawyers. It is about everybody in the society, people at large. Focusing on the social fabric of the society. So they are picking up come one come all phenomena where the constitutional promise that justice to all and justice to at your doorstep. So Sambhav has gone beyond, and they are saying literacy at your doorstep. So they are trying to literate people who know very little about their rights, and who know very little about litigation and the kind of conflicts they can be faced with. Welcome everyone. Going to the topic, can you go to the next slide, please? See, if we just look at the topic, it says National Capacity Building Program on Art of Contract Drafting from Fundamentals to Enforcements. When we say fundamental to enforcement, it means a lot. It is taking you by and large through all the processes that are available. So, first and foremost, we must understand that what do we understand by negotiation? So, negotiation is a process of communication aimed at persuasion between two or more parties to reach a mutually acceptable agreement. So, now why are we talking of negotiation when we are like getting into a contract? Contract means like two people come together and they give their point of view that this is something they want to do. For example, I want to hire, services of from a firm. So, what will be the terms? What will be the hours of work? Likewise, if there is something has to be supplied, something has to be exported. So, first and foremost, we have to identify people who are going to come up to my needs, that if I am planning to have like exporting oil, so who are the recipients, what can they pay, how have they shortlisted me to be the supplier. So and what are the laws which are going to govern how the money is going to come in, how we are going to transport. So in every sector of our life today, from hiring a maid for your house from a agency, you are there talking about what do you want and what can they provide and how they can provide and what will be the terms. As far as monetary concerns are concerned, hours of working is concerned, everything. So negotiation is a process of communication. Communication that we express in words, that this is what we require, whether it is a written or first in discussion, that you come forward and discuss about it and then persuade the other person. For example, that I have to export a chemical to another country, and so I to negotiate that what kind of shipping line will come in, or what kind of who will provide the shipping line, and how which bank will be sending the money, where the LC will be opened. So all of that, all those terms are agreed before you enter into the contract. So all these terms are actually negotiated. Negotiation in a way where you give some and you take some. So somewhere you will be giving in, and somewhere the other person will be giving in. So this is how we come to a mutually agreed agreement. Next slide, please. Now, what is a contract? If we say contract negotiation is all about reaching a mutual understanding between two companies on terms of that are legally binding. So if we are having a discussion between two parties, where there's a commercial transaction or where there's a service contract, where is you are hiring a firm for executing your services, your contract, looking into the legality of the contracts. So when you are having these discussions, So, why are we having this discussion? We are discussing all this so that some terms should come through and backed by reason, that this is what we want and this should be the outcome. In case we are not able to abide by the terms, then there has to be something we can fall back upon. Okay, so contract negotiation is all about reaching a mutual understanding between two companies on terms that are largely binding. So if today, even when the child is asking for a pocket money, he negotiates and he has a monthly thing going on, that this is on this date, you will give me this much money, and this is how I will utilize this money. See, you understand that the it is a basic mindset which starts right from the childhood. ठीक है, protecting you, putting a discipline on the child and expecting him to behave in a particular manner. It is a collaborative process where both sides aim to secure conditions that work in their favor while also reducing any financial, legal, or operational risk. Now each word of this sentence makes a lot of, it is of great importance. It is a collaborative process. Collaboration means automatically we both are working towards the same goal. Same goal, if I am supplying the oil, you are able to sell, you get your price, you pay my price. So it is a collaborative process. Okay, so the world today is of collaboration. So, it is where both sides aim to secure conditions, but in case there is a problem, okay, you are doing your part of the contract, the other person is doing their part of the contract. So if there is some difficulty that arises out of it, shipping line did not come on time, the weather was not good, or something to that effect happens, then who will bear the financial cost? The person has to buy oil from the local market and provide to the his customers, and your chemical which was to go to be exported, it could not be exported. Therefore you are suffering losses of keeping holding it on the coast and then taking it back, paying the demurrage and everything. So it is something to reduce the financials. Any kind of financial burden that comes on the people, one, the person who has who had placed the order, the other person had was to come in, third party was to supply the shipping line, the shipping line was not in place. Okay, so how do we, both are suffering. Okay, though it was collaborative effort to gain, right? So but they both are suffering. How do we have so much of clarity that we minimize the damages of both sides? Okay, not that one person says you are the problem. Yes, there can be a problem with one person, but you have to see, there has to be a way to find out who actually faltered. Was it really his fault? Was it there was some other exigency because of which the fault took place? So when we are talking of these terms, so it all of it has to be very transparently put in a contract, so that with a good mindset, when we are collaborating to move forward to achieve a common goal of good business. So it should not be that damages be pushed on to one person and not to the other. It should be collaborative, it should be so clear, the terms have to be so clear that it should be, they should be able to have a look at it. And then reduce, then legal. Now legal is a very important aspect of a negotiated contract. When we are talking of legal, so earlier, there were disputes. Now as global, we are global citizens, and global market is available to us. So if the export is between two countries and the dispute happens, where it will be resolved? Okay, sorry, for that, for that legal aspect of it, we need something which is, where we can, that which jurisdiction we will go to. If India has exported to China, or to Russia, or to England, so where will be the jurisdiction of that, which court jurisdiction will apply? That has to be very, very clear. Otherwise it can explode into so much of financial loss to both sides that they will go bankrupt. Okay, so the seat of litigation where it should be, and that has to be very clear. Then what should be the process they will follow of legal? Now they have an option. Earlier there was only litigation, but today there is an option. They can go for arbitration, they can go for mediation, they can go for litigation. So all of that has to be dealt with very to a lot of clarity. It has to be negotiated at that given point of time when you are entering into a contract. So then further it is operational risks. As I told you, nobody knew about COVID would happen, and actually COVID happened, and everybody had losses, but everybody wanted to minimize the losses. There was no force majeure clause ever, in the contracts. There was a force majeure clause, but not effect to a epidemic. Okay, so of magnitude of a COVID-19. So there are when we are talking of a contract and why we negotiate and why, so to collaborate, okay, it should, first it is a mutual understanding, then it is a collaborative, it has to reduce the risk, or as far as financial as legal, and it should be implementable. So, why contract negotiation? To have clarification. Now, understand, unless you have clarity in your contract, you will not be able to. Just one second. You will not be able to ensure that it is what you wanted. For example, you say that okay, this the sugar has to be exported to so and so place, and it will be done in a year. Okay, now year is a long time. The whole of year it is not done, and it is done right at the end in December when they don't even need it. Okay, so the terms have to be very, very clear. What are you, what, why, when, where? All these have to be addressed. So every term has to be clarified. Why are we wanting the sugar at this point of time? Why do we want the chemical on this very date? It should be when we are writing entering into a contract, we should back it up with our whys, so that if in case of dispute you have to fall back upon that when we are pointing fingers at each other, that you have done wrong and I am right, and because of you I suffered the losses, you can always fall back upon a contract where you have written very clearly that why did you want this to happen. Okay, so every term of the contract has to be very clear, that if we want that the jurisdiction, the legal aspect of it, that it has to be the seat has to be Singapore. Why Singapore? You have to back it up. It is cost effective, it is executable, it is central place for both the parties. Neutrality may not, we will not face. And why not England? Because it is not feasible, or it would be very, very expensive. They can, so you have to back up all your terms with lot of clarity and wise, that why are we doing it? Because this will be the your Bible to always go back and see that why these terms were agreed. Because once these terms become the annexure of the the terms are the annexure of the main contract, but main contract has to be acting as a bible. So always remember, it cannot be my way or highway. But see, there is a power imbalance sometimes, like, there is a competition in the market. There are so many service providers today. So when we have a service contract, so we bend backwards to say, okay, we should get the contract, and this year, and the targets are very high, and then you're running towards your targets, and you come to the pressure and you negotiate a contract which is not feasible or which is not profitable, and with one smallest of the glitch it will fall apart. So you have to enter into a contract which is mutually beneficial. Again and again, I'm saying that mutually beneficial contract, when we say, it means that mutually agreed legal part of it, mutually agreed benefits, mutually agreed the implementation, and everything should be go it should be for benefit of both the parties. It should not be one way. If you are coming to a pressure, try to bring it to a level where you, if not at par, it is minimized, the difference. So power imbalance has to be reduced when entering into a contract, otherwise these contracts are not workable for long time. Build trust and maintain professionalism. See, if you have clarity on all your terms, and you have all your whys in place, you will have a very good agreement, and you will not have a breach of trust at any point of time, because you have put everything on the table, that, well, I need this, and this is the timeline that I want you to adhere. These are the services I expect from your team, and put the specifications should be absolutely clear. And higher, when it comes to drafting the legal aspect of it, please have a lawyer in place. When you are doing the finances, have a team of chartered accountants there, and do a great level of due diligence before you actually enter into a contract, so that the business runs smoothly. You are not here to cheat and do something, achieve your goals, and not help the other person reach your goal, his the goals. See, in today's times, in older times, like, people used to grow vertically. Okay, so they used to think that, well, for example, iPhone and Samsung. So they were selling their product by saying, I have a very strong screen, and I have a very good, it's a waterproof thing, and the battery life is more. It was a vertical growth. Samsung used to claim, Apple used to claim. If you see today, they only talk of technology. Okay, why they talk of technology? Because they said, let the cases, the hardware be left to the hardware companies. Let them improvise their thing. We will only focus on our technology, and we will compete in the foray of technology. So the thing is, today the world is collaborative, because there is so much of growth everywhere. So we cannot put one person down and move ahead. So we have to go hand in hand. So we must build trust between the parties, and ensure that they enter into a contract where there is no cloak and dagger situation. They should put everything on the table. Yes, of course, they will not disclose their prices and their cost and how much they are saving. That is all is their internal thing. But once they have fixed a price, and they want to supply on that price, that should be very clear. It should be not that they are giving, to some person they are giving for 10% profit, and to other they are giving for 20% profit. So negotiation has to be in a way where there seems to be a uniformity. It prevent future disputes. See, if the terms are clear, okay, and it is mutually beneficial for both the parties are growing, both the companies are growing, and with their help, they are able to provide support to the business community. So there is the likelihood of getting into a dispute is much lesser. And being a mediator, I always say when we get into litigation, we make our good money, bad money. Okay, I'm sorry for the lawyers who are here, but surely I say that litigation is not worth it. It is better to go for ADR, a method. First, try the ADR. See, there are a lot of cases which can only be decided when the courts pitch in. But preferably, it should be focused on a the legal methodology should be where they can mutually decide, they are able to look at their contract, they are able to discuss the communication which breaks down due to the break due to the breach of contract. They should be able to talk. And that is one forum which I think is mediation, which establishes communication between the parties, and they are able to speak their mind in that forum. So there can be a proper legal clause which says that, we will first go for mediation, then we will try arbitration, and if that fails, then the court jurisdiction of which country will be applicable should be defined. So that is very, very important. And encourage collaboration. When we have very honestly put our terms on the table, however strict they may be, once we have put our numbers on the table and given our terms that how we want to proceed with the contract, it always encourage collaboration, because everything is threadbare. There is nothing that is left to the imagination of the parties. Let's go to the next slide, please. Yeah. So when do we start negotiating? And upon receiving the initial draft, so first is the idea that comes to your mind that this is what I want to do, or maybe you are enter into a running business of again I'll go back to supplying some articles like stationery or goods or chemicals, or maybe service and legal assistance, whatever contract. Once you know that this is what you want, and then you talk to the other side, and then you roll out a draft that these will be the terms. That is the very point when you start negotiating between the parties. So either it can be parties themselves, or their chartered accountants, or their team of business team. They can start talking together, talking about it. Upon receiving the initial draft, negotiation at this stage helps amend unfavorable terms before signing. So, even if you have a hard pressing timeline, their timelines are also very compulsive. That you have to finish your work in this particular time frame, and you tend to rush into a contract without looking at the terms. Like insurance policies, when we say that it's very minutely written and we'll overlook the terms. Very interestingly, I was very recently told that if an insurance premium is paid by another person, not your firm, the claim is not honored by the insurance company. So I was not aware of this kind of thing, but so it is very important that right from the beginning, go into the terms. Don't look at the time. This time that you lose on vetting the contract will help you smoothly run your business for rest of the time. In high stake agreements, detailed negotiations may be needed to align both parties in goals. So, when there are high stake agreements, like if you're executing something like a power project, so there will be multiple agreements that will come into place and multiple parties, and it would go from, and hand in hand. You have to understand there are government clearances which have to take place. So for those government clearances, you cannot be committing that I will be getting you the government clearance, because government clearance will come at its own pace. You can only write something like facilitate, that we will facilitate the government clearances. So you have to be very, very careful on the terminology, because that can be interpreted in a wrong way. So have your team, whether it is legal, whether it is financial, whether it is who can look at it and with their point of view and suggest what are the loopholes. Spend your time before starting the business on the contract, and it should be aligned with your goals, because when there will be a dispute, you will see how far you are from your goal, what you wanted to do and what has not been done. That will evaluate your losses. So you be very, very clear on this. When the terms don't align with the objectives, negotiation ensure that the contract supports the goal. If it doesn't, now, for example, the sugar has to be exported, and the consumption of sugar in particular time of the year is far more than the other part of the year. Okay, so you have to ensure that you wanted to send sugar at that given point of time for this reason. Okay, I'm trying to make examples as basic as possible, so that you understand why we negotiate a contract which is workable in the clear terms. When not to negotiate a contract, standardized agreements attempting to negotiate these could create unnecessary delays. So see, the thing is, there are certain standard contracts. Okay, standard contracts, by meaning thereby that um, a like your car insurance, or your your office service contract, the people who are providing services. So there is a a standard format. There's a fixed wages, and so in those contracts, if you will sit down and start discussing, it will unnecessarily waste your time. You have to not get your entire team working on it for details. It can be a small team which works on it, and then it can be signed and moved forward. Unnecessary redlining over negotiation can if you redline every thing, you are in doubt on for every smallest possible thing. Okay, we are deciding Singapore as a seat of arbitration. No, 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 no. Why not in why cannot it not be India? Why cannot it be UK? So if you start putting meaning to it, well, let's put it Hong Kong, or all of that. So you cannot be redlining everything. You have to reason out why, and what is the gain, mutual gain of both the parties. Without adequate preparation, negotiate without clear priorities. Again, you should not negotiate if you do not have your goals in front of you. So you have to ensure that you know what you want to achieve by entering into this contract. So it has to be mutual gain. It timeline should be defined, why we are entering into, and what will we achieve from it. So if this is very clear in you, then you will be able to negotiate it much better. Otherwise, you will keep on swinging with every discussion. Okay, oh, this can also be considered. That can also be considered. So there will be a lot of confusion. Okay, please, next slide, please. Now, what are the steps in negotiation? So, you should know. Now, see, if I'm selling my car, for example, so I know I put it a price of 10 lakhs in the my advertisement. I want to sell it for 10 lakhs. But then I feel that I should get 12. In my heart, I feel no, 10 is not the right price. I need to get 12. But then I have a bottom line. I will not sell it for less than 8. Okay, this is what is the bottom line. So you should know what is your bottom line, which from which if you go down, it will be absolutely futile, and it you will make the losses. So have your bottom line very, very clear. Okay, very important. And then gather information, know about it. When you are talking to somebody who, say, for example, somebody, so you're trying to sell your chemical, or your oil, or your, your, services. So you have to gather information that who is this service provider, what is his credibility, how many defaults he has taken, how many defaults have been there, has he been in litigation before? You have to get every information possible. Then, if I am selling him this at this price, from if he has purchased this from others, how much it has been, how much I can compete, all of that. If the more information you have, the easier for you to negotiate. you know Build repo. See, again, I'm saying today the world is collaborative, it is no more competitive. So we have come a long way, from from saying my might is right, and what I will say because I am the powerful person, the other person has to listen. No, that's not the times anymore. Today, we are in times where we want to move together for the progress of ourselves as well as for the progress of the general public, and so country, and that is very important. So build repo with the other side, and so that the functioning is very smooth, execution of your contract is very, very smooth. Focus on the interest and not positions, very important. That is the core of mediation also, but it is core of negotiation as well. When you are negotiating, you cannot say, oh, this is I am talking to Tatas, they are the best and they're the most powerful, or we are talking to Apple and we're negotiating with them. So you are talking offer, not of the product, but what exactly do they do. Their technology is the best, therefore we are going ahead with, not with, do not identify your business just because of the goodwill. You have to go beyond and see what is beneficial for me. So focus on the interest and not on the position. If we come back and see it in the realm of mediation, so we say that separate people from the from their positions. So if they have taken a position that I am the son and I was the one who was providing, therefore the will from which I'm getting this money, this house, it should have been given to me, not to my brother. I was very young and I was sent abroad, and so I was the one who did it all. And now my father has left a will in favor of my younger brother. So I do not agree with it. So and he was a useless guy, he never studied, and I was sending money, still he failed, like, you know. So you are attributing all your hardship to a person whom you have known forever. So we, in mediation, we say separate the person and look at the problem. The problem is not the person. The problem is the property that is there to be distributed in what way. Okay. So if you will remove the person from the problem, then it automatically you will start thinking how to resolve. But if you will keep on focusing on the person, you will be going against a wall. Okay, so focus on the interest and not on position. What he is saying, I will buy it for on 10% profit. Sorry, I will buy it, I will give you only 10% on the market price. No, go beyond it. Why is he saying so? Can I get this price from the market? So go beyond the position of the other side. Why is he asking? Okay, try to find out why is he asking. Then have a objective criteria. Why? What is objective criteria? What are we going to do if we spend our time here? Is it what we really want? We want our business to flourish. Why, if we spend all our time here, we have seen that all the loopholes we have tied up, and now it is beneficial for both of us, and move towards the objective. Idea is to grow. Idea is to move forward, get more business, get sell and make profit. So that is what is to be seen like in RERA. Now that the builder buyer contracts, what we see, that if we keep on focusing on the that he has delayed, and therefore he should be paying interest. The idea is that today he should deliver my property. ठीक है, telling them that hundreds of your other projects have also failed today, and therefore it is happening. No, look at what is your objective. Objective is that you get your flat, and at the earliest, and if he doesn't give you on time, what is the penalty on him, and then enter into a contract to buy a house from him, from that particular company. So you have to see that you have to go beyond on the objective criteria. Then make the trade-offs. So many a times the like you are not agreeable for a floor, that which floor do you want, and they say ki, okay, you booked this floor but we do not have it now, and we will give you another floor but you have to pay this much extra. Okay, so there is a conflict, and then how do you address it? Either give my money back, give me interest, and I'm out. If you focus on your objective, no, I needed this house, I had given this money, and today, what is the value of the money, and what should be the way forward? Wait for another this thing, or negotiate the price with the option, or take him to the court. So, okay, you have to be, you should know how to trade off and make it beneficial. Now, be patient and persistent. Yeah, this is very important, which we really lack today with the WhatsApp and the speed that we feel in our lives today. The patience is very, very little. If you are patient before entering into contract, having it absolutely clear, you will not end up into litigation, or even if you end up into litigation or in a conflict, you will be able to find a viable process by which you can resolve your conflict quickly. Consider alternative options. If not this, then what? In case he's not able to deliver what I'm asking for, then what happens, right? That also has to be considered. Next slide, please. So as I was giving you where all we look at the contracts. There are employment contracts, there is real estate purchase agreements, licensing agreements, international trade agreements, investment terms, then business partnerships, vendor contracts, union contracts, and then mergers and acquisitions, as we are seeing, and then supply chain agreements. Okay. So broadly, these are the agreements we are looking at, that we see all the time happening around us. And then is the time is very little. I can see 46 minutes have gone by in no time, and I have another 5 7 minutes. Okay, next slide, please. Now, how do we have a thought over and contract which is workable in place, and which is good for both the parties? You should have very sound legal knowledge. You should have a good in-house counsel, or your legal team, or a legal office, law office, which is providing you that how if in case of how this contract is executable in the event it is, if it is not, it is violate, any term is violated, what will be the way forward? Sound legal knowledge you must have. If you do not have, then please take assistance for entering into a contract. Awareness of risk of appetite, as I told you, bottom line, that I cannot go beyond. And in case we run into a problem, how much can I drop my price, and how much losses can I consume? Okay, so always have a awareness of risk appetite. Clean, concise, and communication. I told you, whenever you're entering into contact, whys are very important. Why are we having this term? Why the shipping line has to be provided by you? Why on this date we have to supply the sugar? Why, all of that you have to, it should be absolutely not left to imagination within 1 year. Okay. Or then it should be in four corners of law and your profit, that it has to be clear, concise, and communication. And then you should be able to communicate with the other side. The moment communication breaks down, clarity goes away, and you are not able to know what is happening. Okay. Then is it should, as I told you, I'm a great like mediator, and I want to always promote mediation. As a it should be a non-adversarial process. We should not look at the courts all the time. See you in court should be the last thing to do. First and foremost, try to go for a mediation, and then go for arbitration. And then, in case, see, there are certain cases you have to go for. If it's a trademarks issue, or it is a patent issue, you have to approach the court, right? So, and when there is an interim relief required, immediately you want the stay to take place, you have to go to the courts. Okay. But if to stop the further damages, you need to go to the court. But in case there is some kind of risk appetite, and you are able to have a open dialogue, then please have a non-adversarial approach. Commercial savvy, it should be something which is beneficial and commercially viable for both the parties. Next slide, please. Yeah, now what all are the ticking points where we must focus? Okay, the scope of work, it should be absolutely clear. I will provide the chemical, it will reach the port. I will put it in the form of a gas, and there we need a shipping line on so and so date, which will export. My sphere of my work ends at the port once it is loaded on the shipping line. That's it. So the clarity has to be, scope of work, हमने करना क्या है, हम कितना करेंगे, that has to be very, very clear. Duration and termination, I just told you that the moment you start focus on duration, sugar will be provided within 1 year. No, it will be provided when and why. Okay, reason. Because whenever you are in dispute, the way to handle dispute is that why did we agree to this? Okay, if there is a reasoning, you will always soften on your stand. And then termination. When does the contract end? That is also very clearly, it has to be worded. Intellectual property rights, yes. See, now, there, not only in the commercial sector, even in your like OTT platforms and your movies, okay, your creative content also has a intellectual property attached to it. We see all the times people getting into problems, right? So you have to be very clear that outcome of this will be with whom. The once we have developed the product, who will hold the intellectual property rights about it? Who will have the copyright? Who will have the trademarks? Always remember, the more clarity it is before entering, the better it is. There is no confusion. Why? Why have we discussed? Why have we agreed? Dispute resolution. Again, I told you, when you go into litigation, sorry for saying again to the lawyers, you make your good money, bad money. The mediation is a very cost effective process where communication is the major skill that takes place, and mediator tries to assist parties to communicate. So, dispute resolution mechanism also has to be in place. Confidentiality and non-disclosure, very very important. I'm working with one person on a project, and then somebody offers me on the similar project, and I take up there because I'm getting more money. Please, for heaven's sake, so many mobile phones, so many cars. Why are they like Suzuki and Toyota has collaborated on certain car engines for which they say ki we'll use the same engine, same everything, but the facade outside will be different and the interiors will be different. Why? It is so that the competition reduces, they are able to manufacture more and compete on a limited competition. So these understandings have to be there. And confidentiality and non-disclosure is agreement is very very important. That clause must be there, that what do you want and why. Performance metrics. As I told you, if the terms are clear, supported by reasoning, the dates will be fixed, when to start, when to end, and it will be a very good contract. Then force majeure, as I told you, nobody ever thought that something like COVID-19 can happen ever. And may it be your commercial matters, may it be everything came to a halt, literally, and people did not know how to address it in the legal framework. So if there's a force majeure clause, it will secure both the sides from facing the people whom they were supposed to provide those goods and articles. Next slide, please. Now, how we make a contract which is successful? Define negotiation strategy. Okay, that is another 10 hours if we have to talk of negotiation strategies. So we have to understand that negotiate there are different types of negotiation, there are different type of negotiators. So principled negotiation is taken to be the best in today's times, where so there is a book uh, by William Uri and Roger Federer, that getting to yes. Okay, so you should know your negotiation strategy. How are you going to be? Are you going to be competitive, or you have to be collaborative, or you have to be principled? So so that has to be very clear. Negotiate deals in chunks. Do not mix and match everything together. So collaborate on one, then go to the next, and then to the next. Okay, all should not be mixed up and done. Prioritize your core objectives. Yes, idea. What is the idea? Idea is to develop technology and not the hardware, you know and hardware can be left to other companies to our specifications, right? So prioritize your core objectives. We objective is to have beautiful cars and with beautiful interiors. Compete on the interiors and not on the engine will be something which will be developed at one place only. So that helps you, grow much faster and in different spaces. Negotiate with research. Yes, very, very important. I said have a background check, have a due diligence before you start the negotiation. Compromise for long term benefits. Do not focus on short term ki ye ho gaya, then this contract, like for example, if I have to buy a car and somebody selling me a car. Toyota wants his customers to stay with Toyota, right? So focus on the long term, not on the short term. So when you compare various things in the market. So you want your market share. We keep on talking of the market share. Who's capturing how much market share, right? So always think of long term. How can we grow in not that one time? There are certain things which are one time. One time car purchase is one time. But if the person who was there, he says, "Ki, okay, sir, I will give you the mat, the mud flaps and the foot mats for a smaller price, or this is something extra I can do." The person will stay with that outlet of that particular cards vendor. So always focus on long term goals and not short term. Next slide, please. I hope all of you are getting it what I'm talking. I hope difference between contract negotiation and contract management. So there is one is that when you are entering into contract, when you know your objectives, when you know what you are headed looking for, so then you when that so that is the core contract, which is the and then align the parties and their goals to create an agreement. So you bring everyone together, and it is a contract which is workable for the larger goal. And then managing the contract through its established time period. So now the once the contract has taken place, the main contract, we are going to buy, this is the shipping line, this is the person who's going to receive the goods. So once it is entered into, then the peripheral work. Okay, that is managing the contract. Managing the contract throughout, it is established the time period till the time, from the time it started and till the time it is executed. Okay, that has to be also taken care of when you are negotiating. Typically stored in a secure centralized location. So, advanced features aid in contract renewal. So, it is for you're working smoothly. It has to be, the movement should be kept smooth throughout the process that of execution of a contract, the main contract. So for that, also there has to be understanding that you should have. Next slide. Now, what are the challenges? What happens? Why we fail in a a contract is not workable. Lack of data for negotiations. Scattered contracts make difficult to access data. So I have explained it earlier. I will just quickly go through it because I think I have hardly any time left, if I am not mistaken. Ensuring compliances with legal terms. As I told you, please ensure that how you want the legal aspect of it to work. You have to work it out. Over negotiation and delays. There are certain contracts which need not be negotiated because it delays the project. Ambiguity on terms and language. Please do not use a verbal jargon so that it creates a if this happen, that will happen. If those that those terminology must not be used. Tracking edits and handwritten changes can cause unclear edit. Yeah. So see, the thing is, when you are technologically challenged, which I am, I must say, so it becomes difficult. Okay. So these are certain dealing with unequal negotiation. As I told you, if there is a power imbalance, please don't backward, don't let your client bend backward to enter into contract just because he wants it so hard. Try to negotiate, try to push the person to come to your terms. Okay. Inefficiency in using traditional tools like Google Docs and Words. I told you, man, if you are not like I am not technically very sound, I need a lot of assistance. This can also cause a lot of problem. Next slide. Uh, when we are looking at a negotiated agreement, the terms are better, the clear exceptions are there, improved relationship. Naturally, when it is a negotiated contract, there is a less likelihood of ambiguity and less likelihood of conflict. And if the conflict happens, which can happen in every best of the contracts, there will be a proper way to handle. So your ADR will alternate dispute redressal clause will be there, and then you will have ample protection. So the cons of this is it is time consuming. When we are negotiating a contract, it is very time consuming. I told you that one should make every clause as clear as possible. Why are we entering into it? Okay. So that people, when they are discussing, it takes a lot of time. It is very costly. Yes, you are having a legal team, you have a financial team, and then there is risk of disagreement, and it is a complex way to head. Next slide, please. Any questions? Thank you. And I think we can ask questions wherever, whoever. And I hope I was clear and I was not very quick, and I was try to put everything in as
Sure, sure, ma'am.
fast.
Thank you, ma'am. One participant, sorry, name is iPad. I don't know the name. So over to you. Yes, please. I request you
Uh,
to put your name in every session. Every time you are putting iPad, iPad. So yes, over to you.
okay, sorry. Henceforth, I will get it corrected. This is
No, no
Dattagupta.
problem. You must carry on. Yeah.
My question is, ma'am has told that one point which I am not get clearly. That is from the side number three, I think. When terms don't align with objectives during negotiation, further even then negotiation ensure the contract supports your goal. If it doesn't, so I want some more clarity on this. Can it be possible?
Can you repeat once, please?
It is from your slide only, ma'am.
Yes.
When terms don't align with objectives,
Yes.
negotiation ensure the contract supports your goal. If it doesn't,
Yes. So what happens? I gave you the example. I want to export sugar, and the contract says within 1 year.
yeah,
Okay. But if when while negotiating the term, I said that please, I want this sugar to reach within 1 year. The and in the year of June, July, the
Yes, sir.
consumption is more, and
Yes,
therefore it should be. I don't say that it should reach in June, July, but I say
uh,
the consumption is here, and then consumption is
yes, sir.
in September, October. So I am clear why I'm saying
Yes,
so. Though I did not clearly put my term as that in June, July, so much quantity, August, September, this much quantity, complete quantity by December. I did not say so. Okay. But because while negotiating, I wrote that why, why I want the sugar to go within 1 year. So when you are in conflict, it will be able to help you resolve quickly when you
yes,
revisit the contract. Okay?
yes, yes, sir.
Am I
Thank you.
clear?
Yes, sir. Thanks, ma'am.
Yes. Any other questions, please?
Yeah, this will last question, Amit Bhatt.
Yeah, thank you, sir. Thank you very much for the very powerful session, ma'am. My question is, in case of international trade agreements,
Yes.
do we have any specific forum or anything which can, become a mediation? What happens sometime I draft such agreements? I am really clueless because, as per law, my contracts executed in India is not applicable in other countries.
Let me tell you that it's a very, very important and very valid question in today's time. See, Indian government is signatory to the Singapore Convention on Mediation. Okay, and 52 other countries are also signatory to that convention. Idea of that convention was purely this, that a settlement arrived at in India will be implementable in other countries. Okay. Though we are signatory to the convention, but we are still to ratify it. Okay, we have not yet ratified it. The moment we have got a model law and we have a mediation act in place, but the ratification is still pending. So once it is done, then anything that whether the trade agreement is between like UK and US, if the seat is in India and the settlement is arrived at here, will be implementable in those countries as well. Is that
So, ma'am, can I get the details of that particular convention or so that I can actually research on that? And because I will not never ever will become came to know that when it got executed and whether it has been ratified or not.
if you Google Singapore Convention and people signatory to the convention and what is it all about, you will get it.
I get that, ma'am.
Yeah,
I'll do that.
yeah, I can give it to Hiranshi also if you want, but that is available in the public domain.
I'll search it out.
Yes.
Otherwise, we have Dr. Professor with us.
Yeah.
Thanks.
Yeah.
Good afternoon, ma'am.
Yes, please. Anshul.
Ma'am, Anshana this side. Thank you for such a good session. I wanted to ask you about the internship opportunities in this particular field of mediation, if you could enlighten us.
I know, I know. See, Hiranshi is doing a great job. Where are you based out of? Anshwana, where are you based out of?
Um, yes, ma'am. Ma'am, I'm a second year law student pursuing my LLB from the Delhi University itself.
Okay.
I'm still studying and I'm really exploring internship opportunities. It would
Uh,
be a pleasure if I would like be able to get a chance to work under your guidance and if
uh,
anything of that sort.
there is a Delhi Dispute Resolution Society, which provides that's a purely pre-litigation forum. You can get an internship there. Delhi High Court is providing, Samadhan is providing internship opportunities. You can apply there. And I can find out more if you want, but these are two very important places where you will get a lot of exposure.
Uh, Thank you so much, ma'am. for this wonderful session. And on behalf of the organizing committee, I would like to extend our sincere gratitude to you, ma'am, for delivering such a thoughtful and enriching session today. We are truly thankful to you, ma'am, not only for accepting our invitation, but also for taking the time to guide and inspire all the participants. Thank you so much, ma'am.
Thank you.
Thank
Thank
you.
you.
Yeah.
Yes.
Thank you.
Yes.